You can mention it under this. They are very closely related concepts. Or you can make a separate point also, but fundamentally the ideas that we'll be talking about are quite similar over here. So how do we understand this? According to, alright, which schedule specifically talks about this separation of powers? There is a schedule in the Indian Constitution. Which schedule talks about this? Online students? Which schedule of the Indian Constitution talks about separation of powers in a very detailed manner? It's very simple. It's the 7th schedule. Okay? Yes. So, the 7th schedule lays down 3 different lists: union list, state list, and concurrent list, right?
Is it good, sir?
Yes.
Sir, 1 second, sir, please.
The union list, state list, and concurrent list. Okay? So this is the separation of powers between the center and the state. But I don't mean separation of powers in the sense of legislature, executive, or judiciary over here. That's a different thing. How many subjects are there in each of these lists?
In union list 97.
It's 100 now. Please note these down, they have been updated. There are 100 subjects in the union list.
Sir, beg pardon.
There are 100 subjects in the union list. Just write next to union list. You don't have to write the full sentence. 100 subjects. There are 52 subjects in the state list. And 61 subjects in the concurrent list. Now this is the schedule that talks about the delineation of different subjects on which either the center can make a law, the state can make a law, or either of them can make a law, right? But there is a very specific part of the Constitution that has the articles that make these lists functional. What is that part? Part 11. Please note down, Part 11 of the Constitution provides detailed provisions on you can write down on detailed provisions on legislative jurisdiction. By legislative jurisdiction, I mean the areas in which specific bodies can make specific laws. In more detail, we'll be talking about these things. We'll be talking about the doctrine of pith in substance, the doctrine of territorial nexus, the doctrine of colorable legislation, okay? But not today, not about all of that. So this should give you an idea that there is a federal structure, okay? But is it really federal? Is the government really completely federal? Because what do we mean by federal? Yes?
So it is quasi-federal.
Very good. It's quasi-federal in nature, okay? By the way, who said that Indian Constitution? There is a specific jurist, and this question also mostly asked, who is the jurist who termed Indian Constitution to be quasi-federal? Please note this down, and I won't tell you this answer. Yes? It is Casey Weir. Correct. Although I have a feeling that it could be Ivor Jennings also. For now, let's assume that this is what it is. If it's not, I'll correct it for you next class.
What's the name?
Casey Weir. Casey Weir. Okay. What do I mean when I say that our constitution is federal? What I mean is there is a strict separation between center and state. Center cannot interfere with state, state cannot interfere with center. Right? But Indian constitution, as you're saying, is quasi-federal. Why so? Because there are very specific provisions which say that in certain circumstances the parliament can make law in the state field also, and the moment this happens we can see the federal structure breaking down. What are some instances of this? You can note down Article 249. Article 249 states, when Rajya Sabha passes a resolution that the parliament ought to make a law coming under the state list, the parliament is free to do so. Yeah.
So parliament make law.
The parliament may make a law in the state list. The Rajya Sabha will pass a resolution stating that parliament may make a law in the state list. Okay. Article 250 states that parliament may make such a law in matters of when there is a proclamation of emergency. And Article 252, when two or more states agree for a particular matter to be covered by parliament legislation. Yes, when two or more states, this is Article 252, when two or more states agree that a particular subject in the state list be covered by parliamentary legislation or central law, whatever you want, you can write. Okay, so since we are on this particular point on these articles itself, one quick prelims point over here. There is an article in this series of articles only that I have mentioned. Okay, I'll ask you which one. Which one of them gives the parliament the right to make a law in case of international treaties? When India enters into, when the Prime Minister goes and signs a treaty with another country, gets into an international agreement, obviously some law has to be made with respect to that agreement in the country. So the parliament will make that law. Which is the article that gives the parliament that power?
Sir, it is Article 253.
Very good. It's Article 253. Please write down Article 253. Parliament makes law to give effect to international treaties. To give effect to international treaties.
Sir,
Yes.
sir, when you are talking about the item in the list,
Yes.
state list contains 52 items and the concurrent list,
61 items.
no sir, concurrent list contains 52 items and the state list contains 60.
Okay, I might have exchanged that, so you can correct that. Thank you for the correction. I'm growing old, my memory can fail.
State list.
State list is
Okay. Any other features that come to your mind apart from this? Just think of the provisions that you know. I'm sure you'll come across one other very important point. The judiciary, a unified system of judiciary. Please write this down.
Sir,
A unified system of judiciary. Okay, which part of the Constitution talks about the union judiciary? It's part 5. Part 5 talks about legislature, executive and judiciary at the center. And part 6 talks about, again, legislature, executive and judiciary at the state level. Okay, quickly, which article establishes Supreme Court?
sir, Article 124.
Very good. Article 124. Again, a question on the same lines. Which article establishes high courts? Any answers? You can go through the contents of the Constitution. Make it a habit to look for the answer. You don't have to depend on me for that.
So 214.
214, very good. Article 200, yes?
yes, sir, 214.
214, yes. Okay. So, since we are on this point, is there any specific provision in the Constitution that says that the High Court is subordinate to the Supreme Court? Is there any specific provision that says that High Court is subordinate to Supreme Court? No. There is not a single provision that says that. Okay? But how do you understand from a small analysis that High Court is subordinate to Supreme Court? The appointment of judges. Okay? In Article 217 you can mention, 217 deals with appointment of High Court judges. Now, your High Court judges are appointed by the President in consultation with the Chief Justice of India, very good, and the Governor of the state and in case of appointment of other judges, then the Chief Justice of the High Court, also the Chief Justice of the High Court himself. Okay, now there is also one more thing. You can write down Article 222. I think this deals with your transfer of High Court judges. Article 222. All of these are potential preliminary questions. You don't have to remember the entire provision, just have to remember what 222 basically talks about. So 222 says that High Court judges shall be transferred by the President in consultation with the Chief Justice of India. Okay? So at least these two fundamental points must indicate to you that in a very strong manner the High Courts are subordinate to the Supreme Court. In terms of jurisdiction, in terms of functioning, they are not. But administratively speaking, they are subordinate to the Supreme Court. Clear? Okay. Now, another important, you could say, sub-feature of this particular point itself is independent judiciary. Just write this term down. Independent judiciary. And quickly answer to me, because this particular point creates a lot of controversy, and especially the present Chief Justice of India, the Honorable Justice, Chief Justice D.Y. Chandrachud, he has been in the news for his comments on that. The collegium system, isn't it? How and why am I talking about collegium system? Because when we are talking about an independent judiciary, if you look at Article 124 or you look at Article 217, in both of these sections you will notice that the judges are appointed by the President, no doubt. But the consultation process is with the judges. They are the ones who suggest the names. Why has this been included over here? Because unlike in the US, where judges are politically elected, we cannot have the same situation over here. Why? Exactly, the independence of judiciary will be affected, and it is a direct attack on something known as your separation of powers. The executive or the legislature, either of them, they would be able to somehow manipulate and put people that they support on the panel. The moment that happens, the entire separation between legislative, executive and judiciary breaks down. This is the concept of independent judiciary. What are the other points that indicate that Indian judiciary is independent? Article 125, please take a look at it. It talks about the salaries and allowances of the judges. Okay? Article 125. This is for Supreme Court, and I'm not sure, it might be 218 or 219 for the High Court, salaries and allowances of judges. The salaries and allowances of judges of the Supreme Court are mentioned in 125, that much we are clear about, okay? But do you know that this salary, it has to come from a particular account? Some money account it has to come from. The money account from which this particular salary comes is known as the, very good, it's known as the Consolidated Fund of India. And according to the, I think this is Article 110, that talks about what are the things that come under Consolidated Fund of India. 110, or I guess it's 112. Something to do with estimates, budget estimates, sorry, annual financial statement. 112. Yes, 112. Yes, indeed. In 112, you will notice that there is a list of functionaries. The names have been mentioned, the President has been mentioned, and along with that you will see the salaries of Supreme Court judges, CAG and all of that is also mentioned. Okay? Remember that the moment it comes under that particular definition given in Article 112, there cannot be a debate in the Parliament to reduce that particular salary. Reduce or increase or whatever, but there can be no question, there can be no debating by the legislature on that point. Is this point becoming clearer right now? The moment you take the power out of the legislature's hands to affect the salary of the judges, you will ensure judicial independence. Or tomorrow, a judge gives an adverse decision against the government and the government decide to cut off his salary or take away his pension. This affects judicial independence. So now are you being able to see how all these provisions are interconnected? Clear? Is everyone clear with what the concept of independent judiciary?
Yes, sir.
Okay. All right. Now, the last feature, the most important one over here. There are a few others, but I think for you to be able to answer a long question, if you opt for, the mains exam, this many number of points is sufficient. Amendment of the Constitution. Which part of the Constitution deals with amendments? Part 22. Sorry, part 20. See, I told you I'm getting older. My memory is failing. It's part 20 that deals with amendment of the Indian Constitution. Now, this is something that we'll be talking about in a significant detail in the future. But for now, let's just take note of a few small points over here. Which is the landmark judgment in this particular area? Amendment of Constitution.
Sir, Keshwanand.
Keshwanand Bharti. Very good. Keshwanand Bharti. Okay. So, Keshwanand Bharti dealt with which particular amendments?
Amendment to the preamble.
No, apart from that, there were, I'm talking about the number of the amendment.
So 42nd Amendment?
Keshwanand Bharti, not 42nd Amendment. No.
14th Amendment, sir.
14th.
Are you sure it's 14th or is it 23rd and 24th Amendment?
24.
14th.
Yes, can you repeat that?
Sir, 24th and 25th Amendment?
Yes, 24th and 25th Amendment. Okay. This case laid down that any part of the Constitution can be amended as long as it does not violate the basic structure of the Constitution, right? Now, it is important to know Article 368 gives you the procedure, okay? But remember, Article 13 defines law, right? It tells you what a particular law is, and it then tells you that any law that is passed cannot take away the fundamental rights, right? But now we see that the fundamental right of property has been completely abrogated, isn't it? How did this happen? Now the fundamental right to property has been completely abrogated. We are saying that law includes any particular thing that may amend the Constitution. Are we saying that? No. Remember that if you notice in that article itself, it mentions that Article 368 has nothing to do with Article 13. They are not connected at all. Why? Just two important points remember over here. There is something known as constituent power and there is something known as legislative power. Okay? The argument that was given in Golaknath versus State of Punjab was that the Parliament exercised its legislative power to make this particular law taking away certain rights. Because it exercised its legislative power, it is a law and it comes under the definition Article 13. and thereby fundamental rights cannot be taken away at all. This position, however, was changed subsequently in Keshwananda Bharati, which said that when we are amending a constitution, it is in the exercise of constituent power, not legislative power. Clear? For now, you just need to know this much. The last, I was saying this was going to be the last, but this will be the last now. Emergency provisions. No doubt. Emergency provisions are mentioned in, which part is this? Part 18. Please correct me if I get these numbers wrong.
Yes, sir, it is 8.
Okay, thank you. Part 18 talks about emergency provisions, okay? Now, just a little while before, we spoke about the quasi-federal structure of the Indian Constitution, right? By quasi-federal, we mean that in certain circumstances, Parliament can take away or enter into the arena that is occupied by the state. You can write this statement down for greater clarity. Imposition of emergency is a suspension of the federal structure of a constitution. Yes, imposition of emergency is a suspension of the federal structure of the Constitution. Okay, so there are three kinds of emergency that we deal with, okay? The first one is presidential proclamation or national emergency. This is Article 352. Now, an important point to note over here is that this particular form of emergency can be imposed only when the president wants to do it directly himself. Can it be done? Can the president without any suggestion at all impose emergency?
No, sir.
No. He has to act on, first of all, the fundamental principle is president always acts on the aid and advice of his council of ministers. Very good. Here it is a more detailed and specific provision that says that there has to be a written notification by the cabinet. Okay? Article 356 deals with imposition of, yes,
State emergency.
very good, imposition of president's rule in state or state emergency. Now please write down a phrase right under it: failure of constitutional machinery. And I want you to also take a look at something that you might have missed. This is Article 365. This is not in that same chapter, but please take a look at it because it's very relevant when it comes to state emergency.
Sir, article?
365. This is important from the prelims point of view as well. Effect of failure to comply with or give effect to directions given by the union. Failure to comply with or give effect to directions given by the union. Okay, we won't go into this in detail, but just know that essentially when there are certain directions given by the central government to a state and it does not follow it, the center in this particular situation can take this to be a failure of the constitutional machinery and can go ahead and impose president's rule. Okay. Now, according to 356, again, can the president act directly on his own? No. He will act on the advice of the cabinet. Okay. But if you take a closer look, please open that provision. Yes. If the president, on receipt of report from the governor of a state or otherwise, is satisfied that a situation has arisen, okay, all that is mentioned over here, if we talk about the positivist way of thinking, treat the law as it is, the president can act on the receipt of the governor or otherwise. On the receipt of the governor is quite clear. The governor is supposed to be the representative head of the center at the state level. So if he suggests that a situation has arisen, the president will act accordingly. But over there you will also see there is mentioned or otherwise. What is the meaning of or otherwise? Does this mean that the president can act on his own? He can never do that. Why? Because if you remember, the fundamental principle laid down in Article 74 is the President will act aid and advice of his Council of Ministers in anything and everything that he does. Clear? Okay. Article 360 deals with financial emergency. Very good. You may also mention 358, suspension of Article 19 during emergencies.
So which are
358. And Article 359 as well. 359 deals with suspension of rights conferred by Part 3rd, except for Article 20 and 21. Article 20 and 21 cannot be suspended at all. All right. Okay. We have talked about a lot of concepts till now. Are there any doubts at this point? Any questions? Online students?
No, sir. No, sir.
Okay, I think this overall what we have covered till now has been a good compendium of information when it comes to your prelims exams. So Now I'll start with a discussion of the parts of the Constitution I've already told you, right? You might be wondering that we'll deal with part 1, part 2, part 3. We won't go in that order. We'll deal with the most important parts first. So when we say the most important part of the Constitution, what do we mean by that? The fundamental rights. Okay? So please write down part 3rd of the make a separate heading, different page. Thus far what you have covered is Introduction to the Constitution of India, Features of the Constitution and Preamble. What we are starting with now is going to continue into the next class. Okay? So, part 3rd of the Constitution deals with fundamental rights. As I have mentioned before, it was necessary to mention fundamental rights in the Constitution. Why? Because of the historical background, right? Who were the framers of the Constitution? The framers of the Constitution were the freedom fighters mostly, right? And driven by this very background experience that they had of the atrocities that they were put through, the violence that they had to face, the deprivation of basic human liberty that they had to face and dignity that they had to face. In these situations, they obviously decided it would be important to mention these rights specifically. Why? Because if we are providing for an elected legislature today, the legislature will come to power, it will say that you the people have elected us. Now you the people have given us the right to do whatever we want, right? Because there are no limitations that are mentioned. So these fundamental rights you can write down. Fundamental rights are the basic and inalienable fundamental rights are the basic and inalienable.
Sir, you're not audible.
Yeah, can you hear me?
Was I audible, sir?
Am I audible now?
Sir, your voice is not clear. It's breaking.
Okay, I think it's something to do with the internet then.
Yes, sir.
There is something.
Okay, we can give it a break for a minute. Is it better now? सिग्नल ठीक अच्छी
सर नेटवर्क ही नहीं इंटरनेट
It is not clear.
Can one of you go and call sir? Yeah.
Sir, why you left your camp, sir?
Why did I leave judiciary? See, I am characteristically I'm a free bird. Like I love and I prize my freedom more than anything. And after I entered, I enjoyed the work, but I did not really enjoy the, there's a lot of your freedoms get taken away. There are a lot of ways in which you can and cannot do things, which honestly speaking, it seemed a little too much for me. So that's the reason. But I have nothing negative towards the profession at all. Am I audible?
Yes, sir. Yes, sir.
Okay, all right. There's some magic he did. Anyway, okay, so the definition of fundamental rights. Fundamental rights are the basic and inalienable human rights.
Pardon?
Fundamental rights are the basic and inalienable by inalienable we mean rights that cannot be taken away, cannot be alienated, okay? Basic and inalienable human rights that are inherently possessed by the members of a society and are recognized in the Constitution. Implicitly or explicitly. What I mean by implicitly or explicitly is this. Article 19 talks about your freedom of speech and expression, right? Expressly it talks about it. But does it talk about freedom of information? Does it talk about the right to know? It does not talk about it directly, right? It talks about it indirectly, implicitly. It implies the existence of right to information. How? If for you to have the right to freedom of speech and expression, you can only speak or form an opinion before you speak when you have the correct information. So logically this means that you must have right to information to make right to freedom of speech and expression effective. Right? By this I mean implicitly or explicitly. There are other examples of that also. Article 21 gives you right to life and personal liberty. Okay? This right to privacy is a implied right that comes under that. Clear? Anyway, that's not what we are talking about here. That's just to give you an idea of what the definition means. Is everyone clear with the definition?
Yes, sir. Yes,
All right.
sir. I have a doubt.
Sure, go ahead.
So you said inalienable human rights. So
Yes.
what is the difference between this fundamental means constitution and human rights?
What is the difference between?
Constitution and
These fundamental rights and these human rights.
There is no difference at all. See, these human rights, when they get encoded in the Constitution, when they are written down in the Constitution, they are just called fundamental rights. There is no, how should I say this? Technical difference between human rights and, of course, the ambit of human rights is much wider in that sense. But the only reason or the only way in which they are different is that these human rights are written down in the Constitution. The moment that happens, they are recognized as being fundamental, and that is why they are called fundamental rights. Is that clear?
Yes, sir.
Okay. Any other questions? Any other questions? Okay. So, part 3rd of the Constitution, as you have noticed, talks about fundamental rights. But at the end of the day, when I have a right, when we get into jurisprudence, these concepts will be much clearer. That right has to have a correlative duty in most cases, right? When I say that I have a right, that means someone else has a duty towards me. So in this situation, who has that duty towards me? The government, right? Precisely, the government. But is it mentioned anywhere that the rights can be enforced against the government? Sorry, the rights can, is it mentioned anywhere directly? No, right? Please take a look at Article 12 and 13 and you will understand how we draw the implication that fundamental rights are to be enforced against the government or bodies that are the instrumentality of the state. Okay. In this part, unless the context otherwise requires, state includes the government and Parliament of India, government and legislature of each of the states, and all local or other authorities within the territory of India or under the control of Government of India. Please break this down into 6 points. State includes, number 1, Government of India, number 2, Parliament of India, number 3, Government of the states, number 4, State legislature, number 5, local authorities, and number 6, other authorities. Okay, now take a look at Article 13. Take a look at the second clause. The state shall not make any law which takes away or abridges the rights conferred by this part, and any law made in contravention of this clause shall, to the extent of the contravention, be void. Okay? When we are interpreting a statute, this is very fundamental jurisprudence or interpretation of statutes, whatever you call it. You have to read first of all the basic definition. The definition is given in Article 12, right? 12 says that state means these 6 things that it has given, 5 of which are given very specifically. The 6th one, other authorities, is a little vague. We'll get into that. But state means these 6 things. Okay? Now, this meaning of state, you have to just supplant in this clause. So, when we say from where are we concluding that fundamental rights can be enforced against the government or against the state, these are the 2 things that we need to keep in mind. These 2 provisions read together will give us the implication. Is it clear?
Yes, sir.
Yes, sir.
Okay. Now, state means the government of India. What do we mean by the government of India over here? It's mentioned Government of India and Parliament of India. Then what do we mean by Government of India? We mean the executive, right? The central government essentially. Parliament, union legislature. Government of the state government at the executive level, in the same way, state legislature, right? If we read this and the second clause of Article 13 together, it means that tomorrow, let's say the Odisha state government, if it comes out with a law that says that you cannot drive on the roads after 8 o'clock at night. Okay? What is the fundamental right that is being affected over here? Article 19, freedom of movement, right? Now, this freedom or this right is mentioned in part 3rd of the Constitution. Logically, clause 2 says, the state shall not make any law which takes away or abridges the rights conferred by this part. Right to freedom of movement is a right conferred by part 3rd. So logically this means state government cannot make that law. But again, there are reasonable restriction and all of that, which we don't have to go into right now, but this is just to illustrate how you have to think about these provisions, right? Now, 5 of these 6 points are quite direct, right? State government, central government, state legislature, union legislature. 5th point is local authorities. What do we mean by local authorities? Very good.
Panchayat.
Very good. The panchayats. You can write down the name of a case over here. Union of India versus R.C. Jain under local authorities. This is a Supreme Court judgment from 1981, I think, which in which essentially the issue was whether the Delhi Development Authority is state or not. So the court said that the indicative features of a local authority are independent self-government, local jurisdiction over public functions, local jurisdiction over public functions, and number 3, the ability to raise funds for these functions through taxes and fees. Okay, you can write down another case which is the opposite conclusion of this. Calcutta State Transport Corporation versus State of West Bengal. So in this it was held that the state corporation is a company that engages in providing maintenance services, road services, transportation services. It does not have any of the features that we talked about previously, all the 3 points that you're talking about. Okay, in the previous case, just add a small point. Independent self-government involving elected representatives. Okay, all right. So in Article 12, as you can see, there is a very vague phrase mentioned, other authorities. Okay, 2 words, but these 2 words are essentially if you opt for the optional, this is one entire question, one entire long question that you'll get, which is regarding interpretation of the meaning of state, or how fundamental rights are being enforced against bodies that are the instrumentality of the state. Okay. The reason the constitution makers mentioned other authorities, you can write down rationale behind Article 12 as a heading. remember, as a rule of thumb, in any of your mains questions, when you're writing down answers, divide them into multiple headings. In 2016, one of the strategies that I followed to achieve this is simply to, my content was not a lot, because I used to write leaving space between lines. Yeah, it gives the illusion of writing a very long answer. But the important thing is, the moment you make multiple headings, whoever is checking the papers, it makes it easier for that person to quickly know that you know all of these things, so he is not going to spend too much time into analyzing everything, right? This is a strategy you must follow for everything. Okay, rationale behind Article 12, other authorities. Now, at the beginning, I told you that India is a welfare state, right? Because it is a welfare state, it engages in many public functions, and these public functions it does through its departments primarily. But does it only function through government departments? No. It also functions through government companies, for example, registered societies, for example, right? So when we are seeing that the sphere of government control is being enlarged beyond a government department only, do you realize that in this situation, unless we also include these other bodies in the definition of state, it will give a chance to the state to bypass the law, isn't it? In this situation, let's say that the government starts a company, okay? Let's say an oil drilling company. The shareholding is entirely held by by the government. The functionaries are appointed by the government, and the function that it discharges is also a government function. But we are saying that it's a company, and because it's a company, we are saying that, okay, it does not look like it has governmental character. Is this the right way to go about it? No. Because at the end of the day, remember that the government is discharging its function through the instrumentality of this company, right? And through this instrumentality, it may also choose to bypass a lot of fundamental rights. It may violate fundamental rights, and it will say that, okay, whatever it may be, we are not state. Since we are not state, it does not come under definition of Article 12. We can go ahead and violate fundamental rights. This is the reason why the definition of other authorities has been expanded. Okay, just write a small note down. We'll continue this in the next class. India is a welfare state. Or you can write down, the Constitution lays the foundation for a welfare state. The government functions through its many departments the government functions through its many departments and also other government